and welcome back to Radio Entrepreneurs. I want to remind our listeners we're heard on 3 stations Monday to Friday drive time: WBNW 1120 in Needham, WPLM 1390 in Plymouth, Mass., and WESO 970 in Southbridge, Mass. I'm glad to say in our studio we have our weekly reporter, Mark Furman, reporting in on litigation issues from Tarlow, Hart Rodgers. Mark, nice to see you.
Jeffrey, nice to be with you today.
Good. You haven't had the flu, I hope?
No, I've avoided it so far.
Right.
So I wanted to talk today about a interesting non-compete case. A company called Arbor Networks, Inc. sued a company called Red Lambda, Inc. and a lot of employees. And what happened was Red Lambda hired 10 former employees of Arbor. And Red Lambda was a competitor of Arbor.
What kind of business they in?
They are in the security risk business and the detection of things relating to networks. And although their products work slightly differently, their competitors, and a customer would buy one or the other, but not both. So each of the 10 individuals who were named as defendants, who formerly worked at Arbor and went to work for Red Lambda, did so within 12 months of ending their employment with Arbor. And there was a non-compete in that each of them had signed for a year. Mm-hmm. So the claim was that they each violated the non-compete, and so Arbor brought suit. There was a motion to dismiss filed by all of the defendants, and the case was in federal court, and the court took up the question of whether or not there was enough for the case to survive. And in general, the court decided that the case can go forward, that there was enough evidence that there had been a breach of the non-compete. But let's step back for a second. Employees leave a company, they have a non-compete, they go to a competitor. The key fight is the preliminary injunction stage, which happens right away. You need to get into court and you need to enjoin those employees from being able to work at that company. The decision didn't talk about what happened at that stage, but I assume that there was such a request because in almost every case, time is of the essence. You got to get in a court quickly and protect your rights. So it's just not clear from the decision what happened there. Similarly, for the company who's hired away employees, that's similarly the key stage, because if they're allowed to work, usually the cases eventually peter out. So in any event, each of the 10 employees signed non-competes. They all agreed not to hire, solicit other employees of Arbor. They couldn't compete themselves. They couldn't use Arbor's information. They couldn't make disparaging remarks about Arbor. And one defendant, a gentleman named William Ronca, he seems to have been the first person to have been hired. He had some ill will towards Arbor, according to the complaint. He threatened to retaliate against them. And then he wanted to keep his laptop when he left, and he wanted to take some products or purchase products, which were denied. And then shortly thereafter, within 2 months, he was working for Red Lambda. And then shortly thereafter, each of the other defendants, individual defendants, resigned and went to work for Red Lambda. There were contacts with customers of Arbor.
Oh, so there were. They know about that.
Yeah, somehow from emails, there was alleged communications with Comcast, for example, which was a client. There was an email about putting together a team dinner with Comcast, with the folks at Red Lambda. So there's some fairly good evidence that's alleged in the complaint. This is just the allegations, not a trial, not proven, but the court's just deciding whether enough has been alleged for the case to go forward. So the court said there's enough. You know, at the complaint stage, you don't have to know every fact because you haven't gotten any discovery. But you just have to have a plausible claim that is just beyond mere speculation, something that's completely implausible, can't survive a motion to dismiss. But the court found that there were sufficient facts to support the claim that Ronka breached his contract, made disparaging remarks, solicited Arbor employees, and that they solicited Arbor customers, potential customers, encouraged folks to terminate their relationship. So, in addition, in these cases, you usually sue the hiring employer.
Right.
Because, you know, if they're enjoined from, that's where the money is typically, and if they're enjoined from being able to work with these employees, then, you know, that's critical. So, so unlike the employees who each signed non-compete agreements, Red Lambda, of course, had no contractual relationship with Arbor. They were just old-fashioned competitors. So how can they be liable, you might wonder? Well, there was two theories advanced by Arbor in the case. One is the typical theory, and one sometimes people try to assert with little success. The one that's typically asserted is intentional interference with advantageous or contractual relationships. And that requires that the defendant know that there was a contract, which in this case there was evidence Red Lambda knew, that the defendant induced a third party to break the contract, that's the employees breaking their non-competes, that the defendant's interference was improper in that it either had an improper motive or was done by an improper means, and then damages. So here, Red Lambda acknowledged that they knew they had a contract and there was damage, but they claimed there was no evidence to support the other claims that they knowingly induced breaking the contract or was improper motive or means. Court rejected both of the arguments. On the improper motive or means, well, the court acknowledged you can hire, make an offer to an at-will employee at another company, and of course that's what happens on a daily basis in business. There's other evidence in this case that shows a improper motive. You know, Ronka had threatened Arbor. Now Ronka becomes an employee of Red Lambda, so that motive that Ronka has, now he's part of Red Lambda. So the court said that his ill will, which was alleged in the complaint, is evidence, and that an inference for the motion to dismiss stage could exist that Red Lambda hired with the purpose of violating the non-competes, which is improper competition. So that was rejected. So that left the claim under 93A. We've talked about 93A, common in business cases. It's a Massachusetts law that prohibits unfair or deceptive business practices. But it doesn't apply in every situation. For example, the relationship between an employer and employee is internal to the company and 93A doesn't apply. So the court has held any employment contract disputes are not covered by 93A. That disputes arising out of the employer-employee relationship are not covered by 93A. So employees can't sue employers under 93A, employers can't sue employees under 93A. So that principle applies to non-compete contracts as well. The question here is, does it apply to another business? Does the dispute between Arbor and Reb Lambda arise out of the employment relationship, or is it just an unfair competition case, which in the typical context would be covered by 93A? Well, the court says that this dispute arose out of the employer-employee relationship, and therefore it's not a claim that can be asserted. The court focused on the fact that the agreements that were the major subject of the lawsuit, the agreements between the employees and Arbor, were employment agreements, and therefore that controls. It doesn't change just because you're suing the employer who hired away folks in allegedly in violation of the non-compete. So the bottom line is, from Red Lambda's point of view, they don't have to worry about 93A, which is huge because 93A can provide for triple damages and attorney's fees, and it becomes a straight forward tortious interference claim against them, where everybody has to pay their own lawyer.
Well, you know, we're still sitting here with the offended company missing 10 employees, having to pay court costs, and probably with a lot of damage to its business.
Yes, I think I read that it was a third of the workforce or sales force of Arbor. A giant hit for Arbor, and a giant benefit to Red Lambda. So it'll be interesting to see what happens. This could be one of those rare cases that that have legs, that keep going, these non-compete cases, because the damage could be significant. But keep in mind why it may not be also, because these employees could have gone to work for Red Lambda consistent with without violating the non-compete. It's a question of prematurely going.
Right.
And so the question is, in proving damages, if you're Arbor, and when the people could have left a few months later, it gets pretty challenging.
But what's our takeaway? What can we learn from this as entrepreneurs? I mean, again, if I'm Arbor, it doesn't make, or someone like Arbor, it doesn't make me feel more secure about my non-competes, because this is costing me a lot of money, and the potential of losing employees is still there, and losing clients, even though I had my employees sign these things.
That's right. The non-competes are hardly perfect. They're controversial. You have, the courts are ambivalent about it. They're enforceable in Massachusetts to the extent they're reasonable, but they can be cut back. They can be cut back time, geography. There are all these defenses that can be raised to non-competes. There's proposals to eliminate, make them illegal like they are in California.
And if you're a potential Red Lambda, the legal costs of dealing with this, and maybe even some of the damages, may cost less than what it would have cost to do sales on your own. It's a cost of doing business to take the competition out.
But here the court said that according to the complaint, prior to Ronca's employment with Red Lambda had one salesperson on its staff, and that the current sales force consists primarily of former employees of Arbor. So in effect, what Red Lambda did was
an acquisition.
They did. they acquired a sales force, and the cost of litigation from their perspective may be quite minor. And
that's what I'm saying.
Right.
So here they were able to, if you're able to acquire a sales force, it's in essence acquiring a business for a nominal cost.
And that's why I think the 93A decision is an important decision, because 93A really changes the cost-benefit analysis, if you have the risk of being responsible for triple damages, plus you have to pay the plaintiff's attorney's fees, that's a lot more risk.
Especially those attorney's fees.
That's right. It's a lot more risk. So I think it's an important case. And, you know, non-competes are
Will you bring this back to
imperfect.
us? This
I
is going to
will.
be an important case for us to talk about,
Yeah.
and we can do a review at some point. My name is Jeffrey Davis. We're talking to Mark Furman of Tarlow, Hart Rodgers about non-competes and a current case in the Massachusetts courts. Mark, if someone wants to get hold of you, talk to you about their non-competes, how to lock them in tighter, how to deal with them, how would they contact you?
I can be reached at 617-218-2025 or at mfurman, Furman, at tbhr-law.com.
Great. This is Radio Entrepreneurs. We'll be right back after this break with more stories.